And then aside from that, this court finds that there's no showing that a temporary injunction is necessary to preserve the status quo. There is nothing in the affidavits to show that any of the plaintiffs have complied with the order, that complying with the order has somehow harmed them. I get theoretical that if I had to follow this, this is what would happen to my business. I reviewed again, and which was the only one which gave me pause, the affidavit of Mr. Miller about whether or not he could book venues, but he does not give me the dates. I don't know if they were after this order or before the order. I don't know what dates they are. It would have been helpful if you say because of this, during this time period, he was unable to book venues, but that's not what's there. It is the movement's burden to show me that this injunction is necessary to preserve the status quo. I don't see that anything is different if I don't issue the injunction. No one's saying they're complying with the order of the secretary. Nor is there anything in the affidavit showing that they've been threatened with a civil penalty by any authority. And finally, I find that there's no showing of irreparable harm. If I had a showing for the last 40 days that businesses were going out because they were that would be a showing of irreparable harm. I merely have the theoretical issue that if they were to comply, they would suffer harm. I also take in consideration it's limited. There's 20 days left from today. I'm assuming that that is accurate. Based upon all of that, I find that plaintiffs and interveners have not shown that they are entitled to a temporary injunction, and I deny their request.